apresentar a nossa penúltima aula do professor Kellogg, e eu espero que vocês tenham podido acompanhar bem e sobretudo, entendê-las. Nós estamos mandando para vocês as traduções. Nós gostaríamos, inclusive, de anunciar que, após a última aula, na semana seguinte, nós queremos, na segunda-feira, nós precisamos nos reunir todos, nós, eu, vocês e Pedro, e nós discutirmos uma série de problemas relativos ao curso. Então, vocês já ficam convidados. Então, nesse momento, eu passo, então, a palavra ao professor Kellogg, que vai dar início à sua nona aula. Yes, Kellogg, go ahead.
Good morning, and welcome to the 8th lecture in the topic of democracy and social conflict, how we govern ourselves between elections. We're seeing how our interactions and everyday life, even our arguments and disputes, can and do contribute to our social choices. We think and act as individuals, and we also think and act as a group and as a society. We respond to shared problems through interactions and disputes. These are the source of our shared knowledge and our social order. The polarization of our time is very disturbing. Can we make sense of it? How about seeing it in a broader context of dispute and conflict? If we see the world as always confronted by problems and in constant transition, then we can and should see ourselves as inquirers and problem solvers, makers of change, not victims of it. As the famous physicist Marie Curie, who won the Nobel Prize in 1903 and 1911 for her discoveries of radiation, as she said, quote, "Nothing in life is to be feared. It is rather to be understood." How? By recognizing at the outset there are stages of social inquiry into all problems, small and large. And the first stage is one of social uncertainty. Uncertainty is disturbing, disruptive. This is especially true when problems arise from a need to adjust or change embedded habits. When there is resistance and conflict, does that mean one side has to win and the other lose? That's not the only possible outcome if social habits can adjust. Habit adjustment and change is the challenge in the problem of bullying, in the preservation of nature and the climate, even in habits of thought and philosophy. Habits are reinforced by language and belief. The great polarization arises from resistance to habit change. Solution requires that habit and language must adapt. Of course, elections are of great importance, so I don't underestimate the importance of fair and truthful democratic elections. But even they take place within a context of ongoing discussion and dispute, and even new legislation comes from a context of dispute and often outright conflict. In times of great uncertainty, we can't depend on elections to bring us out of it. We should recognize that conflict, as well as the electoral and legislative process, depend upon a background of fair and truthful conduct of disputes. Democracy cannot be successful without successful ongoing resolution of the disputes about social problems. Even the progress of science has depended on a process of fair and truthful inquiry. That, of course, is John Dewey's whole point in bringing empirical naturalism to ethics. Dewey was unique in his approach to democracy, one that does not entirely depend on elections and government institutions alone. He saw democracy as intrinsic to community life, but he struggled to define his own meaning during a time that was dominated by other habits and beliefs of politics and philosophy. He was opposed by so-called democratic elitists, skeptical of public intelligence, who thought that only experts could run society. And he was opposed by an approach to moral philosophy that was dominated by analytical approaches drawing from utilitarianism and emotivism. By comparing Dewey to these approaches, I have interpreted his approach, his own approach, and his unique vision in a manner that responds to our condition today. In doing so, I have emphasized more than he did the role of social conflict in our self-government. Dewey would agree that the resolution of disputes is essential to the solution of our current and continuing problems. His notion of empirical naturalism in ethics means bringing ongoing human experience to the resolution of moral problems. Last week, Plato's dialogue, the Euthyphro, raised the ancient and difficult problem of moral justification. This dialogue brings us back to the theory and philosophy of law and to the work of another pragmatist who has also been misunderstood, the American judge Oliver Wendell Holmes. Today, we examine his contribution to the fair and truthful resolution of legal disputes. And we will also see that he has the same problem as Dewey, the ongoing failure by leading scholars to recognize that important contribution. First, consider that story of Socrates about to be tried for impiety, for corrupting young Athenians with his constant questioning and his skepticism of claims to absolute truth. He meets Euthyphro, who is about to prosecute his own father for starving to death one of his employees who himself had killed a slave. So we have here two cases raising a general question: how to justify a particular action. Socrates wants to justify his practice of skeptical questioning, and Euthyphro wants to justify prosecuting his father for homicide. These are both difficult cases, hard cases, as they say. What should we do about such so-called hard cases without clear answers? The question of justifying them is stated by Socrates in that famous quotation, how they would be viewed by the gods of Athens. He says to Euthyphro, quote, "The point which I should wish to understand is whether the pious or holy is beloved by the gods because it is holy, or holy because it is beloved by the gods." The gods here are omniscient and their opinion would be right for all times and places. So translated into law, the question is whether right is right by nature or by human enactment and convention. Socrates had no answer 5,000 years ago, but I said that his problem came from focusing on the particular case, not the larger problem. If we look at contemporary legal philosophy, we also find the same failure from the same source, failure to recognize the social continuum of inquiry. Both of these cases can be seen as early examples of larger questions. Socrates' prosecution was for exercising free inquiry, for his uncensored philosophical questioning. This conduct is now highly regarded in our culture and valued in a free society. Euthyphro's issue, too, is also one that has been examined and addressed by the law of justifiable homicide. The answer to Socrates lies in seeing that the difficult case can be part of a larger problem. Life is full of uncertainty, and it is not enough to walk away, as Euthyphro does. When it comes to the difficult case, pragmatism asks a different question from Socrates. Rather than asking how the gods would view this or that case, the uncertain case, pragmatism asks, is there a problem? A bigger one than just this difficult case? If so, where are we in the continuum of inquiry? Should this case be seen as a smaller question within a larger question, the lowercase q in the capital letter Q? We might add that it can take time for the social continuum to reach a conclusion. Habits are involved and language. Consider Socrates' offense, that of freely questioning authority. It has taken time for us to reach acceptance of free speech and thought, and it is still denied in many parts of the world. The continuum of inquiry can be a long one. As Martin Luther King said, the arc of the moral universe is long, but it bends toward justice. Holmes and Dewey would add, not necessarily, we have to bend the arc, and that will inevitably mean fighting for justice. Oliver Wendell Holmes Jr. was the son of a doctor and a scientist. His first job out of Harvard College in 1860 was a soldier, wounded 3 times in the American Civil War. Returning from the Army to study law, he was disappointed with Harvard Law School, so he started his own graduate school, one-on-one talks with other brilliant young Harvard graduates, all engrossed not just in law, but in science and philosophy. Those talks were informed by philosophy, English experimental science, and profound curiosity. We should picture the young Holmes discussing the great philosophers like Kant and Hegel with brilliant friends like William James and Charles Peirce in the years following the Civil War. The war was a failure of legal order. It was perhaps also a failure of European philosophy. It cast doubt on both Kant's categorical imperative and Hegel's historical synthesis. The war focused Holmes on the threshold of human success and failure and the conditions necessary for success, which he would apply to the theory of law. bending the arc toward justice is not assured. Not until recently have we seen such clear evidence of that. Holmes was a true child of conflict, a soldier who physically felt the conflict in 3 physical wounds from enemy weapons. However, like Dewey, misguided criticisms have dominated his legacy. They have come from a very high academic level, like Harvard professor Lon Fuller in 1940, from Yale professor Grant Gilmore in the 1970s, from the University of Chicago professors Alan Bloom in the 80s and Albert Altshuler in 1999. He has remained the subject of criticism even today. Only 8 years ago, a distinguished Columbia law professor, Philip Bobbitt, gave a lecture that reiterated the view of Grant Gilmore that Holmes is responsible for exacerbating Socrates' profound puzzle over the difficult case. Gilmore called the last century an age of anxiety caused by the conundrum into which Holmes and the legal realists had led American law. What conundrum is that? The 20th century legal realists, influenced by Holmes, who had died in 1935, challenged the view that judicial decisions are mechanical deductions from existing rules or principles, and argued instead that there are always opposing rules and principles. So judges had to decide first and boldly rationalize their decisions. Law was simply, as Holmes had apparently said, judicial behavior. If law was simply what the judges did, asked Professor Bobbitt, then how could they be ever, from a legal point of view, be wrong? But judges often contradicted and reversed each other and themselves. So how could they ever be right? But Holmes had not actually said that. What he actually said and thought is subtle, original, and widely, if not uniformly, misread by legal scholars. It concerns the logical method of law. Rather than judicial behavior, Holmes viewed legal adjudication as part of the struggle among active and often opposing forces in society. A struggle not just between rules or even ideas, but patterns of belief and conduct. Legal knowledge must be grounded then in the ultimate resolution of broad conflicts. Professors Bloom and Altshuler took the criticism a step further and insisted that Holmes was a relativist, someone who denies any fundamental truths. Law Without Values was the title of Altshuler's book about Holmes, and Holmes was guilty of promoting it. Professor Fuller had claimed that Holmes had removed morals from law. Let's put this in perspective. How do you define the really hard case? Is it not covered by, if it's not covered by any authoritative legal text, is it ever indeterminate, as many philosophers think, that is outside the authoritative texts? If so, do judges have to legislate? Or instead, do they ever have to look outside the law and resort to moral principles? If so, what if 2 principles conflict? There's always at least 2. Think about Dr. Kevorkian's famous case in 1999. Was assisted death murder or suicide, pitting the right to autonomy against the right to life? Holmes was deeply aware of these problems, but he avoided the currently popular vision of a hard boundary around law, which comes from contemporary legal philosophy, and also the idea that a hard case could be decided by vague values or absolute truths. Reassessing Holmes's logic requires a new understanding of the role of judges in controversial cases. The conundrum of legal realism is still a problem, but Holmes is not responsible for it. Demonstrating this takes us on a journey through his career. It involves Holmes's post-Civil War diaries, his early reading in philosophy and science, his discussions with peers, especially Chauncey Wright and William James, his response to lectures on logic and scientific induction by Peirce in 1866, and his own early essays probing and responding to John Stuart Mill's system of logic. Then we explore his work as a judge. The conundrum problem of law is rooted in logic. Classical logic since Aristotle has been framed by two procedures, deduction and induction, governing the relation between, as Holmes would have put it, generals and particulars. What in a difficult legal case is the logical problem? In an easy case, it is whether I brought my car to a complete stop at a stop sign. There is a clear rule and a clear act, a plain particular governed by a general, decided by deduction. Difficulty increases with the complexity of unanticipated acts that have combined to cause a claim of loss or harm. Where deduction from existing rules is inconclusive, the question approaches becoming an inductive one. Properly understood, induction seeks to find from experience the general rule that will resolve not just the case, but the problem. The problem may be a new one, not yet covered by settled authority. Is medically assisted death suicide or murder? The relevant particulars then are not just the particular facts of this new case, but the judgments or findings in a succession of cases, very much like the succession of experiments in chemistry or physics. For example, there used to be an experiment in high school physics where students would pour liquid mercury into a clean test tube and turn it upside down. If you do this, a space unexpectedly appears between the tube's rounded bottom and the heavy liquid through which no air could have passed. Is this an empty space, or is there some substance in that visible area? How, thought Thomas Hobbes in the 17th century, could such a space paradoxically be filled with nothing? Hobbes was a plenist, a view opposed to vacuism, and he opposed the experimental scientist, the famous Robert Boyle, whose experiments with an air pump explored this complex scientific problem on several grounds. While Boyle chose to do experiments, Hobbes favored a deductive method of inquiry, appealing to the abstract proposition that a space had to be filled with something. It took a succession of experiments by Boyle and others to find an answer. This example will elucidate where Holmes was and is misunderstood, and why he is innocent of blame for the conundrum. Surely, when deduction works, law is what the judges say it is. But where a new matter falls cleanly outside or between settled general rules and propositions, Induction from experiment is required to revise or renew prevalent belief and conduct. Sufficient experience may take time to gather and evaluate. That is when judges may understandably and quite legitimately appear to contradict and reverse themselves and each other, and as also have scientists, at least since the 18th century, working on successions of experiments to see whether, for example, the empty space in the test tube is something we often now and often inexactly call a vacuum. Like scientists, judges don't and shouldn't choose first and rationalize. Rather, like juries, they must surely choose, but not prematurely rationalize, as did Hobbes in opposing and actually denouncing Robert Boyle's famous air pump experiments. What scientists have used is an inductive process, which Holmes and his friends knew to be regrounded in Francis Bacon's 17th century empiricism, and which they also knew had recently been re-examined by Mill and William Ewell in the 1840s. It was examined and refined again by Holmes in the years following the American Civil War. The most profound and misleading criticism of Holmes has come from the idea that law and morals are separate. Many of you may have seen me do a chart like this one, which has law with a circle around it, morals on the outside, and the question whether morals can get into the boundary. That's the idea that law and morals are separate is called legal positivism. And it's a word that transferred from science to law in the 19th century. Positivism is defined as a philosophical system that holds that every rationally justifiable assertion can be scientifically verified or is capable of logical or mathematical proof, and that it therefore rejects metaphysics and theism. The Englishman John Austin, a utilitarian and friend of Jeremy Bentham, focused on defining law as commands of the sovereign, which he saw as verifiable. His approach was criticized and replaced in the 1950s by Oxford professor Herbert Hart, and now legal positivism is redefined as the theory that laws are to be understood as social rules, valid because they are enacted by authority or derive logically from existing decisions. And that ideal or moral considerations are outside and should not limit the scope or operation of the law. Hart was influenced by the analytical and linguistic drift of 20th century philosophy, which we discussed last time. All versions of positivism assume a hard analytical boundary around the phenomenon of law, one that obscures any notion of a transformative continuum. Hart's definition of law was as a system of primary and secondary rules. Primary rules controlled conduct, and secondary ones governed the conduct of legal officials. Hart held that legal change takes place internally according to the secondary rules of recognition, change, and adjudication. He accounted for legal difficulty with the notion that legal language is vague and has an open texture. And then, as you know from prior lectures, Ronald Dworkin opposed Hart's view and insisted that the law contains moral principles and that judges can refer to them. He also created an imaginary judge called Hercules, who was so brilliant that he was able to see all of the relevant moral principles and figure out which one applied to a particular case. Rather than assuming a hard boundary, Holmes clarifies a dynamic relation between morals and law, in showing how ethics and moral knowledge can be the products of conflict. There are 3 points here. First, new moral knowledge is generated in conflict of conduct as well as opinion. Second, this requires extension in both time and space, in the sense of extension of time and extension within society. Ethical inquiry is a product of broad experience throughout society and often requires considerable time to reach stability. Finally, this is because it requires transformation of conduct as well as discourse and persuasion for resolving serious conflicts, if they are to be finally resolved at all. In demonstrating this, let's examine some key events in Holmes's career as a judge. We first turn to the 1890s, when Holmes was chief judge of the Massachusetts Supreme Judicial Court at the height of his ability, but before he was appointed to the U.S. Supreme Court. Then I will jump backwards 30 years to the 1860s and focus on his early reading and writing after returning from the Civil War. So, first, in the 1890s, I consider 2 speeches, 2 lectures by him, and 2 dissents in legal cases, that is, opinions dissenting from the ruling of the rest of the court. The 2 speeches were the famous Path of the Law to the law students at Boston University in 1897, and another in 1899 to the New York State Bar Association, and that was entitled Law in Science and Science in Law. The 2 dissents were in 1895 and 1900, and both were dissents to decisions that outlawed picketing by labor unions. The principal criticisms of Holmes can be traced mainly to one source, the first speech, Path of the Law, in 1897. There he said, quote, "Law is the prediction of the incidence of the public force through the instrumentality of the courts," unquote. Note, he did not say that law is whatever the judges say it is, which is what almost all scholars have taken away from this. He's talking here about the long term, not just the immediate decision. He's thinking about law as a stream of problems, not just the isolated opinions in particular cases. Another remark in the Path of the Law, the first lecture, was his warning to the law students of, quote, "a confusion between morality and law, which sometimes rises to the level of conscious theory." This line has been a troublemaker for Holmes, beginning in 1940, when Professor Fuller attacked him for removing morals from law and reinforcing the claim of relativism. That misses the real meaning of Holmes's warning, as well as the prediction comment. He's talking here about how law students should interpret legal terms that have moral overtones. Don't assume that they allow you to introduce morals into the hard case. The assumption is that if you do, they'll be your own personal morals. Finally, all this ignores an address he gave just 2 years later, with a notably different tone, speaking not to law students, but to the worldly New York lawyers. It also ignores what he wrote in the 2 dissenting opinions, where he voted to sustain the right of unions to picket. When Holmes delivered the 2 addresses and wrote those 2 dissents, he was in his late 50s, Chief Justice of the Supreme Court of Massachusetts. So what was going on in the 1890s? Today's troubles may seem tame by comparison. Barbara Tuchman in The Proud Tower describes the Western world in turmoil, riven by socialism and anarchism, and the two movements were readily associated with each other. Socialists were rallying for workers' strikes everywhere, and European heads of state were being assassinated by anarchists. In Chicago, we had the Haymarket bombing in 1886, where a peaceful rally for striking workers was disrupted by an anarchist bomb that killed 7 police officers. In 1892, Andrew Carnegie lowered wages at his Homestead, Ohio steel plant, caused a strike, and then brought in the army. He crushed the union, leading to 12 deaths. Into all of this came the legal issue of whether workplace picketing was permissible by law, especially by unions seeking to organize other workers. People knew picketing could lead to violence. Holmes Court first voted in 1895 to disallow it on constitutional grounds, citing violation of freedom of contract guaranteed by the Massachusetts Constitution. When Holmes dissented, he was not looking for promotion to a higher court. He took a position 180 degrees against common opinion, a position which would absolutely disqualify him for the Supreme Court. And he knew that, as we can see from his correspondence. But President Theodore Roosevelt, who appointed him in 1902 to the Supreme Court, he became president due to the assassination of his predecessor. These two dissents by Holmes offer crucial evidence for us. Why did he dissent? He said 2 things. First, that the case was not decided by a constitutional phrase protecting freedom of contract, because general propositions do not decide concrete cases. Okay, why not? And what does? His opinion suggests the point that this is an early case on an open and controversial matter. Remember the stages of inquiry. It was an early example of a prospectively broader inquiry, and all relevant facts were not yet on the table. The early case may not be fully representative, and the general issue cannot be decided in advance. But deciding on the constitutional contract rationale would have done exactly that, decided the entire issue in advance. Think of Thomas Hobbes asking how any space could be filled with nothing, jumping to a simple, untested proposition and a deductive opinion. As we now know, Holmes had been deep into science 30 years before, and in a letter to Morris Cohen in 1919, he said his skeptical attitude in law actually came from the scientific way of looking at the world. So back to his second speech in New York in 1899, a year before the second labor dissent. It is filled with more relevant evidence, but it is indirect evidence. Instead of zooming in on legal language, Holmes first zooms out, sees the big picture in a sweeping history of law. Much of his speech is a recap of his famous treatise, The Common Law, but its title is Law in Science and Science in Law. Why science? Because it's a grand analysis, a reflection on both legal and scientific knowledge, especially the question of uncertainty. Holmes asks how deep uncertainty is resolved in addressing human problems, scientific or legal. Holmes saw law through conflict, and cases often came as part of a broad social controversy. He says in 1899, quote, "It seems to me well to remember that men begin with no theory at all, and with no such generalization as contract, They begin with particular cases, and even when they have generalized, they're often a long way from the final generalizations of a later time. Where does this come from? The answer is it comes from John Stuart Mill's 1843 System of Logic, which Holmes read in 1866 and discussed with his friends. Where did Mill get it? From Francis Bacon, the 17th century English lawyer and scientist, the great empiricist who railed against conclusory thinking. So this really involves the early roots of logical questions of treating generals and particulars. To the New York lawyers discussing legal change in 1899, Holmes takes pains to show the lingering influence of ancient practices on contemporary law, just as he did in the common law. This reveals three things. First, he sees the roots of litigation in addressing the practice of revenge, still evident in legal doctrine even today. Second, it raises the question, how does law change, including deep conceptual change? And third, he's talking about the hidden underlying importance of practices and patterns of conduct. The source of legal conceptions lies in ancient and changing practices. Thus, if law is to solve big problems, practice and habit must flex along with legal language. So how about Mill? His influence back then in the late 19th century, his influence was huge. His concern in his logic was the grounds of thought, the origin of conceptions. Mill found this origin in simple comparison of particulars. You compare one thing with another and see if they're the same. Any conception, wrote Mill, originally found its way to us as a result of comparison. Holmes disputed this as early as 1870, after his friend, the pragmatic philosopher Charles Peirce, had criticized it in 1866. Comparison is like a visual process. It assumes a single, stable platform of observation with an omniscient observer or observing mind, not a real world like that of the law, which consists of many viewers and their opposing comparisons, and indeed the opposing habits of the interested parties. Before writing his treatise, The Common Law, in 1881, Holmes had spent several years revising the legal encyclopedia of the day. He found stability throughout much of the common law emerging out of interaction among different points of view, grounded in habits and conduct. When necessary, they can converge, but rarely by immediate fiat, by a declaration by a judge or even a legislature. Legal thought originates in disputes over problems, and convergence may take time. The empiricist Francis Bacon was the key to his early research, especially Bacon's attack on bad intellectual habits. In the 1899 New York speech, Holmes turns to bad intellectual habits. He uses legal examples. His first example is assumption of risk, a common way of deciding for business against the injured laborer. Even if a worker is injured by defective equipment, the employer can trot out the argument that the worker had assumed the risk. So I'll quote Holmes. "Lately have we not all been bored to death with volenti non fit injuria," which is the Latin phrase for assumption of risk. "I blush to say that I have been as guilty as the rest. Do we not hear every day of taking the risk, an expression which you never heard used until within a very few years? Holmes, end quote. Holmes is resisting the temper of the times. This is not an illiberal, cynical judge displaying a bad attitude toward workers. He's asking what assumption and what risk. Here's Holmes again. Quote, when we say that a workman takes a certain risk as incident to his employment, we mean that on some general grounds of policy blindly felt, we read into his contract a term of which he never thought. And the real question in every case is, what are the grounds and how far do they extend? End quote. Here we have an answer to why he dissented to the rulings against picketing. What was the actual activity complained of in picketing? What precisely was the harm? Think of Socrates questioning free speech, the right to free speech, to free expression. Legal logic is embedded in society. It works within society in solving real problems. Just like science, it begins with particular judgments and puts them together with professional care into generalizations. How this professional care works was Holmes's obsession, and the analogy with science is obvious. Holmes explains his attack on accepted legal formulas. Like assumption of risk, they do not represent a final analysis, but he says they dodge difficulty and responsibility with a rhetorical phrase. Difficulty and responsibility. What does that signify? What is not dodging difficulty and responsibility? The answer is frankly not obvious, but it becomes clear in examining where this attitude came from. After Holmes had returned from the war in 1864, he and other Harvard grads, Peirce, William James, Chauncey Wright, John Chipman Gray, they would get together and discuss American experience in the context of the history of Western thought. They read Kant and Hegel, but they all looked back to Bacon's 1620 Novum Organum, which said, quote, there are two ways of inquiry into truth. The one flies from the senses and particulars to axioms of the most general kind and treats them as unshakable truth. And this is the method that is now in use. He's saying this in 1620. The other calls forth exact axioms from the senses and particulars by a gradual and continuous ascent. Now, Holmes was saying the same thing as that was going on in 1620 is going on in the 19th and the 20th century. Bacon's phrasing indicates that logical induction is extended in time. I think most lawyers and judges really know this, but they need to ground it, which is what Holmes does here and what contemporary legal philosophy does not do. But why is it missing today? The late Justice Sandra Day O'Connor, known for her narrow, fact-based opinions, was criticized for that by both liberal and conservative commentators who want the absolute truth. To be fair to the critics of Holmes, Francis Bacon is missing in Holmes's later writings and hence ignored by both his critics and his defenders. But if you look carefully, Bacon is certainly not missing from the record. He has been overlooked in the set narrative about Holmes's influential but supposedly shallow place in American legal thought, a view rooted in attitudes that came after his death. Today, Herbert Hart of Oxford is the truly profound thinker. But it is Bacon who illuminates Holmes's speeches and opinions. Bacon explains the warning to the law students against moral language, the warning against premature use of principle, not against principal jurisprudence per se. But Holmes equates law with predicting the public force through the courts. He means the outcome of an extended inductive process in which principles come at the end. Lon Fuller, professor at Harvard, in Attacking Holmes in 1940, was standing up for American values, like Altshuler, attacking him in 1999 with his book about Holmes called Law Without Values. Hey, who's not for values? But to paraphrase Ringo Starr, you know they don't come easy. At the end of legal inquiry, they take on a gritty realism. Legal principles at the end are not bland, expressing what Holmes often called a benevolent yearning. The great Yale scholar Alexander Bickel wrestled with defining legal principle, and he eventually concluded that the High Court should work toward principle, not from it. But he, too, was blocked from Holmes by the dominant criticism and didn't profit from Holmes's own insights. Instead, he quoted Abraham Lincoln, quote, "As our case is new, so we must think anew and act anew." Lincoln is said to have read Bacon's essays while still in Springfield, Illinois. For the clearest evidence of this whole account, we should read the truly extraordinary Second Labor Dissent of 1900 by Holmes. He apparently, as the Chief Justice, took his brothers, judges, his brethren on the Supreme Judicial Court, and he took them aside and gave them a seminar on legal method while they were still considering the second picketing case. And it worked, at least this once. He got them to admit in the second case that using the constitutional contract rationale was improper judicial method. So they actually dropped the contract claim. He basically told them to address the facts, go back to the law books, and come up with an argument from precedent. What's your legal analogy? They did this, but they still didn't reverse themselves. They simply adopted a rationale that picketing was like extortion. This may seem like no progress at all, but Holmes actually celebrates this in his own second dissent. Much to my satisfaction, if I may say so, says Holmes, the court has seen fit to adopt a mode of approaching the question which I believe to be the correct one, and to open an issue which otherwise I might have thought closed. The difference between my brethren and me now seems to be a difference of degree, and the line of reasoning followed makes it proper for me to explain where the difference lies. For Holmes, the purpose was not directly concerned with wages. It was a degree more remote. The immediate object and motive was to strengthen the Union society as a preliminary means to enable it to make a better fight on question of rate of wages or other matters of clashing interests. Holmes is really talking about the longer view. Instead of on principle, he places this case on a borderline between opposing analogies. He concedes that judges might pick the wrong analogy in an early case, but still keep the issue open. He has a Baconian faith in full inquiry, that facing all the facts, as in repeated raw experience, will eventually gain the day. He wants to give induction time and space to work. His own experience suggests that when induction is not allowed to work, crucial disputes will be resolved in some other and perhaps violent way. This is the profound effect of the Civil War on Holmes's philosophy. In adding conflict to Mill's comparison model, he brings logical inquiry into the real world. Mill was a great optimist. Education was the key to progress. Concepts from Mill came from bald comparison. For Holmes, concepts, theories, solutions all come from the clash of habits and practices. If the basis of induction is mere comparison, then education and dialogue is all you need. But if thought involves dispute, you need adjustment of opposing habits and practices. And this can take effort and time. Unfortunately, it's not an easy message to sell. Much easier is the counter-argument in favor of values and principled jurisprudence. We saw how the appeal to American values was used against John Dewey. It's like candy. The vague idea of values is comforting. Lincoln used the word enthralling. They often parade as the case against relativism, that the only truly principled judges can save the country. Let's go back to the remark by Holmes in the second picketing dissent. The difference between my brethren and me now seems to be a difference of degree. How can we accept that as an approach? Here again, the best explanation might be a response to criticism. Professor Richard Epstein of the New York School of Law wrote a book in 2008 called Supreme Neglect, Attacking Holmes for his 1922 opinion in Pennsylvania Coal Company versus Mahon. That's the first case overruling what has come to be called a regulatory taking. That means basically classifying a particularly intrusive regulation as an unlawful taking of private property. The case involved a state law that limited liability for damage caused by mining operations in a case where houses actually collapsed because of the mining. Holmes saw it as unique, nearly without precedent. Nevertheless, he said in 1922, in ruling against the mining company, that limiting liability on those specific facts just went too far. Professor Epstein jumped on this. He writes, all liability questions demand yes or no answers that are best obtained by bright line rules. Holmes' too far question turns a bright line question into a matter of degree for no good reason. Thus, he says, Holmes got to a sound result, but by a wrong path, thus plunging the law of regulatory takings into intellectual incoherence from which it has never escaped. This case is an early case, and what Epstein is talking about is the uncertainty that still surrounds the question of regulatory takings. But he's assuming that Holmes should have spun out his own philosophy, which would, of course, have supposedly Epstein would have agreed with. He wants Holmes to become a conservative, principled justice in an early case, rather than letting the issue play out over time. Holmes's insight is simply this. Sure, the new case can implicate moral principles, and sure, they're relevant, but they're also in dispute. Epstein's principles may be better described with Robert Boyle's experiments as hypotheses in the same sense as Holmes's theory of contract, the articles in the Yale Law Review, and the particle nature of light. They may, in the course of inquiry, supply an explanation. Holmes' theories eventually did. Many theories in the Law Reviews do not. And the particle nature of light is still in play. Without fresh ideas, the law cannot grow. Judges have a duty to the future, not just the immediate future, but to the distant and yet unenvisioned future. We are today not immersed in the impossibility of indeterminacy. We are in the middle of social uncertainty. We are in the middle of a profound and challenging inquiry. Every dispute, every conflict is a process. The bitter division today, like the Civil War, covers a multitude of distinct problems. It won't go away until there is some set of resolutions. The division reaches down into countless particular claims and disputes. How the law responds to them is the critical issue. Law is our only formal, rigorous means of exploration. It will set the tone. Rarely has the legal profession had this much attention and this much opportunity. Holmes' legal logic is timely for contemporary thought. When Holmes says the life of the law is experience, he highlights another choice, a fundamental one, between analytical and empirical philosophy. I have claimed that analytical legal philosophy is not just useless today, it's positively dangerous. It blocks out the necessity of hard choices. It leads to the conclusion that judges in a difficult case must either legislate or resort to their personal values. As Holmes and President Lincoln, too, both saw a century and a half ago, this attitude simply will not get us through our profound uncertainty. So in the next week, I'll talk about habits and justification, and I'll see you then. Thank you very much.